Hard and fast rules can often be exactly that. Made fast and delivered extremely hard. It would be a fool then to believe that this makes them undeniably correct or indeed infallible. Although not all rules are designed or delivered in this manner, it is generally accepted that rules are created and implemented with the betterment of circumstance at their core. Why then do we also have the commonly held concept that at times it's okay to bend the rules, or even further still, that the rules are made simply to be broken? What then should we do when the circumstance the rule is applied to is not simple, not simply black or white, and not simply containable within a one-size-fits-all scenario? When rules are tested by the application of opinion and perspective, they often seem to be mere guidelines to be challenged and strategically bypassed. Add the complexities of mental health, the wants of victims and supporters, as well as the question of ongoing public safety, and you have a situation where we will test the bounds of being flexible while maintaining the ground rules they apply to, here on the next episode of Just Lawful.
Adelaide is the perfect place to set a horror story. You know why all those films and books are always set in sleepy conservative towns? Because sleepy conservative towns are where those things happen. Exorcism, omens, shining, poltergeists. Adelaide is Amityville, or Salem, and things here go bump in the night.
Welcome again to Just Lawful, where things do indeed go bump in the night. My name is Daniel Panozzo, and I'm once again joined by my co-host, Sean Fuster.
Thanks, Daniel, and thank you everyone for joining us for this next instalment in our series on the intersection between mental health and the criminal law.
Indeed. As always, before we begin, a huge thank you to everyone who was listening, whether you've heard us on the broadcast through 5AA or you've managed to hear our episodes on one of the podcast platforms, either iTunes or Spotify. If you haven't heard the previous episodes in this series or any of ours, we'd love for you to strongly recommend that you go straight to iTunes, Spotify, subscribe, leave us a 5-star rating, do whatever they allow you to do. And that's how you can help us get our word out to those people who might really benefit from hearing what we're doing and catch up on our journey so far. For this episode, similar to our last, if you do find anything we discussed distressing or have someone who you know or you think may be in a vulnerable state, please make use of the following support resources. The South Australian Government Mental Health Triage Service on 131465. They're a 24-hour, 7-day-a-week service that provide advice and information on mental health emergency and crisis situations. The Acute Crisis Intervention Support Line on 131466. If you have someone you believe in a vulnerable situation, they can call on your behalf and help them through that very vulnerable time. That's obviously our local resources. For those interstate or overseas, please seek out and make use of your available resources in your area. Sean, we've covered some really diverse ground so far when we talk about mental health and how that butts up and converges into the world of the legal system. It's fair to say this next episode takes us into a very interesting intersection once again.
Yeah, we're going to deal now with what happens on the other side of the process. We've talked a lot about Section 269. We've talked about how someone can be found not guilty by reason of mental incompetence. We talk about the fact that they are sentenced not to a jail term, but to a limiting term. We've talked about the fact that that period equals the period of a prison term that would be imposed had the person been aware and capable of committing the crime, had it actually been ruled a crime as a result. So we all know that when someone finishes a prison term, they get parole.
Correct.
What happens when someone finishes a limiting term? And that's what I want to talk about in this episode.
Yeah, that's a really interesting point, Sean, for me, simply because, once again, just hearing you lay out, I guess, that algebraic formula, if you like, of how all that comes together to understand what a limiting term is, how it's applied to a situation that is a criminal act that's not deemed to be criminal by the person who has undertaken that act, yet is not responsible from a mental capacity perspective of that situation. even as I say it, it's very confusing in that point. Once we navigate that, whatever that limiting term is, and hopefully at that point we've been able to get someone some treatment, some support, and they've been able to improve their circumstance and situation, you're right though. What next?
Well, let's talk one more time. Let's go back to our lodestone on this of how we define a limiting term. Let's go back to the words of Judge Adam Kimber. A limiting term is not punishment. It is to be a term equivalent to the period of imprisonment that would have been appropriate had a person been convicted of the offence. This is to be set not taking into account your mental illness. It's an appropriate period of supervision relevant to the conduct. It's to enable treatment to be conducted and to allow the community to be protected while that treatment is undertaken. A court is to have regard to all the matters that would normally be relevant to the fixing of a sentence, but not matters arising from mental illness. Couple of key points there. It's to allow treatment to be undertaken and the community to be protected. With parole, the concept is you're in prison for as long as it takes to do your time, what you owe to the community for your crimes.
Yeah.
And you will undertake rehabilitation while you're undergoing that period of time. With a limiting term, though, you don't necessarily serve your limiting term the entire time inside a secure facility. In South Australia, the secure facility is called James Nash House. But on the grounds of James Nash House, as we've talked about in previous episodes, there's Ashton House, the step-down facility. That's where you move when you're deemed to be ready to start reintegrating into the community. Lower security, less guards, the ability to walk around the grounds, use the gardens, do a bit of gardening, things like that, have people come visit you. While you're living in Ashton House, you can also start having day leave. Starts with multiple people going with you into the community, just to a coffee shop.
Mm-hmm.
Think about how confronting it would be if you've been inside a mental health facility for 5 years, 8 years, 10 years, to suddenly walk back out into the public. The last time you were in public, you weren't in your right mind.
That's a really interesting point, Sean. And that's, I guess, the other side of that coin. We think of it from, and quite rightly, and in Adam Kimber's statement, and one thing we talk about is that public safety piece. And that's, I guess, where you and I and those people listening are thinking from, we are the public, that public safety. There is another avenue and another piece to think about this. That person who is then hopefully serving their limiting period has got that rehabilitation, has got some treatment. They need to re-immerse themselves back into the community. That's got to be a frightening situation at times for them also. And I guess that's part where it's not front of mind for us because that's not the world we live in. And that's the other side of this coin I mentioned that really needs to be taken into consideration also.
So let's extend a bit of empathy to Jaden Lower, who we talked about on our previous episode.
Indeed.
Jaden has been floridly psychotic the majority of his life. He has no concept of the real world. Let's cast the minds forward 20, 30 years. Say that Jaden is now at a point where he can be considered for step down.
Sure.
And he needs to go out into the community for the first time and go to a coffee shop. He may as well be landing on the alien planet that his delusions were telling him that he needed to go back to, because he's not going to have a concept of how to order a coffee, to talk to somebody at a counter, because the last time he encountered any of this, he wasn't seeing it the way it actually is. So when you go out on those sort of trips, you've usually got two people supervising you, two forensic mental health specialists, telling you, sit down, it's okay, it's calm, explaining to you what's going on. The better you get, the more supervision comes off.
Of course.
Then if you've got a supportive family member, the supportive family member starts taking you out for the day. But you're always coming back to Ashton House to sleep at night.
Yeah.
Then as we saw in the case of Vicky Wagner, eventually you get to a point where you are considered safe enough to the community to be released. It's not a quick process.
No, and it's certainly that, I was going to say, it's that slow burn transition process that there's checks and balances along the way to make sure that, I guess, that advancement is progressing as it should be to be able to let someone back into the community for both public safety as well as their own.
And one of the things that's part of this slow burn process is what's called a next of kin report. And that is a report that comes not only from the person's family, how they're feeling about them coming back into the community, but the family of the victim.
Of course.
How do they feel about this? Now, the veracity, the use, the value of these next of kin reports is debated.
Okay.
I'm not saying it's debatable. I'm saying it is debated.
Right.
There are some people who will tell you that they're an exhaustive document that give the court a really good insight into how people feel.
Mm-hmm.
And there are others who will tell you that they are as badly edited, chopped up, and minimised as victim impact statements can be.
Can I take a stab at that and say that perhaps depending on which side of the legal bar you're sitting on might be a really good indication of what your perspective might be?
You're getting the hang of this, kid.
Yeah, it's funny about that, isn't it? So with that in mind, and I think to highlight that, what we want to do now is we are going to shortly step into a case, and we're going to give you the outside, I guess, the elements of what occurred at this point, just so you can understand, I guess, and it's not a nice case, let's be honest. It's a pretty horrible situation, but we want to do that so that you have some elements and understanding of what gets someone to that point of needing that treatment in a limiting circumstance. We also then want to see, off the back of knowing those circumstances, when it is time that limiting circumstance has been done, how do we start to look at reintegration? Should we start looking at reintegration? Who has a say in that piece of reintegration and what that's going to look like?
And ultimately, where that balance is struck between community protection and rehabilitation.
And that is the piece, isn't it? It's really that balance between the two. There's a lot of different perspectives in this. To be fair, it's a case that you and I have discussed, and there's a lot of elements we pull apart. It's fair to say I'll be interested to understand where, I guess, the mindset and understanding of our listeners come down on which side they want to go.
Daniel, I want to take you to April 2011,
Okay.
to the suburb of Hectorville, which is east of Adelaide.
Mm-hmm.
Corbus and Annette Sneeman had flown into Adelaide from South Africa
Okay.
to visit their daughter and son-in-law on holiday. Luke and Rika Mombas lived here with their family, their young children. All of them were making new lives for themselves. South Africa at that point, as I'm sure many people remember, was gripped by some fairly concerning violence.
Indeed.
And some fairly tumultuous political issues. So the whole family believed moving to South Australia was a good idea.
Sure.
Corbus and Annette were thinking about, maybe we'll make the move as well. It's a quiet, peaceful night. Luke and Rika's son Marcel has his friend Joshua Graves sleeping over. They're going to have a good night.
Mm.
And that all ended in 90 seconds.
Okay.
Believing that the devil was telling him to do it, the Momba's next-door neighbour, a man by the name of Donato Corbo, burst in, armed with a shotgun, and started firing.
Yeah, right.
Total nightmare scenario.
Yeah.
Doesn't do it justice. Within 90 seconds, 3 murders, 2 counts of attempted murder, 1 count of threatening life. Corbus and Annette died. Luke died as well. Rika was able to get out unscathed along with Joshua. Poor Marcel suffered injuries as well. But before it all broke down, 2 police officers were called.
Right.
2 very brave officers by the names of Travis Ems and Brett Gibbons.
Okay.
Officer Ems slipped in blood and permanently wrenched his knee, trying to save Officer Gibbons, who was shot in the face at close range.
Yeah, right.
Both Officer Ems and Officer Gibbons survived, but as I said, Luke Mombas, Corbus and Annette Sneeman all died.
Sean, this is, as you said, a scenario that goes beyond the concept of a nightmare situation. And you said this concept of 90 seconds. But talk to me about, how does this occur? Like, where does this get to have this horrible nightmare of 90 seconds actually occur?
Donato Corbo was known to have mental issues.
Okay.
It was known up and down the street. His father owned a shotgun.
Okay.
And there would be later made allegations that the gun had been stored improperly, that Donato knew where the keys were, that the ammunition was stored too close to the gun, that it was too easy for a man in his mental state to get his hands on a weapon. Now, all those charges would eventually be dropped.
Sure.
Went through the courts, whole nother thing.
Right.
Donato, of course, was arrested, ranting about the fact that the devil was telling him to do this.
Yeah.
And of course, very soon the reports came back. Paranoid schizophrenia, incapable of forming criminal intent.
Mm-hmm.
This is a 269 case.
Yeah.
It's going to be a not guilty plea by reason of mental incompetence.
Right.
So I said to you, 3 murders,
Mm-hmm.
2 attempted murders, 1 aggravated causing harm with intent.
Yeah.
all washed away.
Yeah,
On
right.
the objective elements that we've talked about, absolutely, those would have been crimes.
Sure.
But Corbo was incapable of forming criminal intent due to his illness.
Yeah.
Ergo, not guilty by reason of mental incompetence, meaning limiting term, not prison term.
And right there is, I think, one of the first points where a lot of people listening are going to, I won't say struggle, but they're going to question, because the immediate sort of response to that is, no, someone has to be held responsible for these actions. And I think that's the first point where a lot of people struggle to go, how do I reconcile that this has occurred, yet I have to accept that someone's not necessarily criminally responsible for that situation?
And look, those feelings are completely valid. Rika Mombas told the Supreme Court, "I couldn't believe what was happening. It was unimaginable. We didn't do anything to this man for him to do such an inhuman act to us. He has destroyed our lives and our happiness. How could you kill people like that? How could you shoot at children?"
Yeah.
And Joshua's father was even more direct. He looked at Corbo in the dock and said, "Anthony, I hope you can hear me. First of all, you are a bastard for murdering my friend and his parents-in-law and for attempting to murder his son and the brave young police officers who came to my friend's aid. If vengeance was mine, I promise you, you would not be with us today. But your act, despicable as it is, can be forgiven if you repent your sins and accept Jesus. That is what my best friend Luke would have wanted for you."
Yeah.
Now, I should point out there he called him Anthony. Donato Anthony Corbo.
Okay.
Known by everybody on the street as Anthony, but I'm going to be referring to him as Donato
Sure.
because that's what I'm used to through court. The police officers, Constable Ems. "I was trapped inside the house for several minutes. I can remember everything that happened in that house, and I feel I will constantly be in that house for the rest of my life. I feel as though I'm still trapped, like my soul never escaped, like I'm still trapped in that bedroom."
Yeah.
So obviously, there's going to be no criminal recompense for this. Nobody is going to be held accountable. But we have a person who clearly is too dangerous to be in the community.
Absolutely.
Having heard that a limiting term was the best they could hope for,
Sure.
the Mombas, the Groves, the officers all got together and they begged the Supreme Court not to allow Corbo to be released.
Okay.
They said, "We don't just want a limiting term.
Sure.
We want an indefinite limiting term. We don't want there to be any hope of him ever being found rehabilitated enough to come back into the community."
So, quick question around that. So, we know that in other times where a criminal charge is upheld for murder, it's a life sentence with a 20-year minimum before we can think about parole.
That's right.
When we talk about a limiting circumstance like this, is that possible to apply the same numbers?
You can apply the same numbers, but it doesn't work the same way.
Right.
You can apply a life limiting term.
Sure.
You then determine how long a person is going to stay in detention.
Right.
The court effectively says, when it comes to questions of wellness, we are not the arbiter of that.
Sure.
Come back to us when you're well, when your doctors say you're well, and then we'll talk about how you step down. So you have people living in South Australia right now who have committed, in a criminal sense, murder, who are back in the community, living under a limiting term of life. They're still going and getting mental health treatment once a week.
Okay.
They might be required to have injections, required to take their medication. They're living on what I'll call, for ease of understanding, mental health parole for the rest of their lives.
So this goes back to that point you made earlier, that under that limiting term, it doesn't mean it will be served in a particular facility the same way a jail sentence would be. So that's kind of the example you're giving there.
That's right. Think about, let's go back to Steve and Janet from the Hillier triple murders. They're horrified by the thought that within 30-something years, the killer of their grandchildren will be able to live in the community.
Sure.
But they know they've got 30-something years of peace with him being inside jail.
Yeah.
For the Mombas, there's no guarantee.
Okay.
Corbo could, and it wouldn't happen this way, but someone could mentally become well within 6 months or a year.
Sure.
And then we start talking about step down because it's a different set of factors.
So you said that they collectively got together and just appealed to the judge, please, we don't want this person to ever come out. Can we have a limiting circumstance where they're never released?
Now, having explained all that to you, do you think that that's something the court could do?
Unfortunately, because of the way you put that, no, we can't, because we can't necessarily deem the detention piece has to be served in a particular facility dependent upon their own capacity.
And talking about just versus lawful, there's nothing lawful about keeping somebody in a secure mental health facility if they no longer require that treatment to that level.
And I think that right there is going to be the second point, if we haven't really hit that a lot of people are going to struggle on that. Yeah, I get what you're saying, Sean, but how can we... Because as you said, from a just perspective, you can't detain someone beyond what they're supposed to be detained.
And another point,
Yeah.
If Donato Corbo is taking up that bed, what about the next person that needs that bed? So it is meant to be a rehabilitative system.
Yeah.
And that's what Justice Michael David explained to them. He said, I'm sorry, I don't have the power to do that, but I'll be concerned for the public if Corbo is not detained, given his mental state. He said, of course, Corbo can make an application in the future. If he makes an application, he will have to come through the courts. Nothing can be done behind closed doors. Because even if psychologists sign off on him being ready for release, the court still has to agree with that evidence.
Right.
Without prejudging anything that will happen in the future, such an application would be frightfully academic. Strong words there from Justice Michael David.
Indeed.
He's effectively saying, as far as I'm concerned, this man is too ill to ever come back out.
Right.
If this man is not detained for an extended period of time, that would be of great concern, he said, because public protection is paramount.
Right.
Interestingly, Corbo's lawyers at the time even agreed. They said, it is clear Mr. Corbo is unwell. It will be some considerable time before he is even able to make an application for release. So in July of 2012, Donato Corbo was given a limiting term of life and sent into detention.
Okay.
Any conversation about letting him out was, by all sounds, a considerable time away.
Sure.
And in Justice David's estimation, academic.
Right.
Do you want to play a guessing game of how long that lasted?
We're here in 2021, and I'm hoping at this point that we're still ongoing, Sean.
August 30, 2021. Yours truly walks into the Supreme Court and finds himself face to face with Joshua Groves.
Okay.
No longer the 11-year-old that escaped from the house,
No.
but a fully grown man,
Yes.
sitting in the front row of the courtroom looking at Donato Corbo on the video screen, as Donato Corbo's new lawyers said the time had come to consider him for step down.
Okay.
Again, we're talking 10 years.
Yeah.
No, I can hear you all out there right now. Nobody gets 10 years for murder. Absolutely. But on the law, Donato Corbo did not murder anybody. He shot and killed 3 people.
Yes.
He shot at many other people. He's responsible to injuries to 2 police officers that will last a lifetime, but he's not criminally responsible for those things.
Yeah.
And so as a result, the time has come, according to the doctors, to consider him not just for release from the secure mental health facility, but to start having, and I quote, brief periods of supervised leave from James Nash House. Remember I explained to you the step-down process.
Sure.
You leave James Nash House, you go to Ashton House,
Sure.
you then start going out in the community. They're wanting him to go out from the community from James Nash House.
So we're missing a step here.
We are missing a step. It's possible there's no room at Ashton House. Ashton House, to my understanding, only has 10 beds available.
Okay.
So that may be a case of, look, Donato, we can't put you in Ashton House. We would, but we can't. So let's start the step-down process from James Nash House.
Okay.
But despite what Justice David said about everything will have to go through the court, this isn't done behind closed doors, I can't give you much more than my speculation on this, because these sorts of reports that underpin these decisions,
Sure.
that underpin these applications, aren't usually released to the media.
Right.
So I'm operating in a bit of a vacuum here. I'm telling you what I know, and it's not a lot. Trish Johnson, the lawyer for Donato Corbo, says he has a new psychiatrist treating him, and she's certainly in support of this application. A new psychiatrist. My question is, how new? How long? How's this been going on? Did the previous psychiatrist say it was time? Is this something that the new psychiatrist has come up with? Where is all this coming from? And when is Rika Momba's going to have this explained to her? When are the police officers and their families going to have this explained to them? When is Joshua Groves, who's sitting there in the front row, going to have this explained to him? Now, fortunately, the DPP said, look, one report is not enough. Given the complexities of this particular case, we would ask for 3 expert reports. 3 reports would allow the court to have as broad an understanding as possible of Mr. Corbo's situation. And now we're adjourned off until later this year. I don't have an outcome for you.
Sean, I am really hoping right now that our listening audience, like myself, has had the opportunity to have maybe take a deep breath and just consider what you've just been telling us. And I know, and I'm going to try the best I can here, so bear with me. We are talking about an individual who has caused death and serious and permanent injury to others, has been given a limiting term, has potentially gone and had treatment and worked through a recovery process, has since got a new psychiatrist, you said, and within the space of 10 years, despite the fact that we had a judge saying it should be a very long period of time and it should be, please remind me here, purely academic.
That's correct.
If any sort of application was put in, that this person should not be returned to our community because they are such a dangerous individual. And within that space of the 10 years I mentioned, we are talking about a step-down program that's going to, for whatever reason, bypass one of the core elements of those steps to potentially looking at this person in some capacity returning to the community. Okay. Again, I'm taking a deep breath and just absorbing and trying to digest all of that, like I'm sure our listeners are. Is this an element going back to the essence of what Adam Kimber was talking about? How does that play out at this point? Help me understand. Is that like for like? Am I missing something here?
I don't think you are, and it is a really hard one when it comes to Donato Corbo and to cases where the violence is against someone outside the family.
Well, that is something that's, I won't say completely unique. However, it's a somewhat unique element. It's not someone within that family dynamic we've seen in other cases, and it is that nightmare scenario you talked about.
Well, to play a strict numbers game for a moment, and I apologise in advance for the brusqueness of this comment, this is Jaden Lower times 3.
Right.
In some ways, Jaden Lower times 5.
Correct.
More people have been injured in a single course of violence than were by Jaden Lower. Jaden Lower is not going anywhere anytime soon.
No.
Jaden Lower is someone who was desperately trying to seek help.
Correct.
For years before he could get it. There's an element of tragedy there that is drawing Jaden into that as well.
Sure.
With Corbo, you don't have that.
No.
You have an acknowledged and known history of mental illness. You have access to weaponry in some form or another. You have, for want of a better term, a powder keg situation waiting to go off. And now, as you say, after just 10 years, it's time to take him to the coffee shop and get him used to the idea of operating in the real world. I would love to say that this is a positive sign because it means that Donato Corbo is healing. He's not hearing the devil in his mind anymore. He is getting better. I truly and deeply hope that is the case. How do we find the security and the comfort in that when the amount of violence perpetrated was so great?
Yeah.
That's my question, because Judge Kimber talks about the community's protection while you rehabilitate.
Yes.
Does it take more time to rehabilitate from destroying 5 lives than it does from destroying 1? Does it take more time to rehabilitate when you have been seeking help your entire adult life versus when you haven't been? Does it take more time to rehabilitate when the victim is your mother than it does when your victims are strangers? These are all the X factors that we don't have the answers to.
Those are the characteristics I talked about right at the start of this. We're talking about a system based on rules that are, for want of a better term, designed for one-size-fits-all because they're trying to take care of the majority of situations the best they can. We get that. We understand there's cracks in the system and all of that. However, we're talking about a situation where none of this is black and white. Everything you've just mentioned is on its own merits of its own characteristics. None of them are really, it's not like we can measure one against the other because it's not a like-for-like circumstance of a situation, a perpetrator, a victim, a reason for that, a mental illness. None of those are like-for-like measurable. So when we're talking about that, it's dare I say, impossible to be able to say this is a distinct and correct amount of time. Does 10 years feel right? Hell no. It just feels like that's not okay. And even as I say that, I have to step back and go, yes, but based on everything we know, that's not a fair and reasonable statement for me to make because, as you also said, you don't even have the documentation to tell you what is or isn't actually occurring here. So how on earth am I going to sit here and be able to make any sort of plausible decision around that?
And that's exactly the point I'm striving toward, because right now there are people out there like Dr. Paul First, the head of the state's mental health forensic service, who are brilliant, brilliant minds, who are listening to this going, Sean, Daniel, what are you going on about? You don't know what you're talking about. You're right, Dr. First. Neither of us are psychiatrists.
No.
Neither of us are psychologists. We acknowledge the same paucity of understanding that we had in the domestic violence series that we recently completed. We want to understand.
Correct.
This is where the transparency that Justice David talked about needs to be at the paramount point. This is where we go back to that concept again of this is not my job as the journalist to be explaining this.
Sure.
I should be the conduit for this explanation. Absolutely. But it shouldn't be me trying to trawl through these cases to explain to you why Donato Corbo is dealt with this way, while Jaden Lower is dealt with another way, and Vicky Wagner is dealt with another way. These things do not make sense to me. I cannot make sense of them to you. We cannot make sense of them to other people because we don't understand.
Yeah.
And then when we try to seek greater understanding as journalists and we apply for access to the psychological reports, to the limiting term conditions, to all the documentation, we're told no.
Yeah. It's a heck of a situation to find ourselves in, Sean. And let's just recap because we talked about that. We've now got Donato Corbo looking to seek his ability to start the step-down process. We know we've got Jaden Lower who, that poor soul is troubled, as we know, and likely is never going anywhere under any circumstance because of his situation. And then we've got Vicky Chapman's situation where, she has successfully gone through that process and is now back in the community.
Has not turned up in court ever since, has caused no issue to anyone else.
Absolutely. So we've got three very distinct situations here.
And that's why we picked these three cases to talk about, because we wanted to
Absolutely.
give you all the broad brush approach to this
Correct.
and show you that there are different outcomes.
The next step that we want to do with this is we want to talk about a couple of more cases and how specifically they apply to what do we do when we want to actually get out of here and the sentencing around limiting circumstance. So what's the first one we want to look at in this sense?
Well, what's unique about these next two, Daniel, is that they both happened on the same day within 15 minutes of each other.
Okay, so as if it wasn't contrasting enough to have two new versions or situations to apply to this mix, or mess, should I say, you've also got the rare and I guess distinct situation that they happen within 15 minutes of each other.
It's one of those moments where people accuse me of making it up. You couldn't have written it in a script. But September 14th, 2021,
Okay.
I start my day by going to the case of Cherie Hazel Laurie.
Okay.
Laurie was found not guilty of torching the Ambassador's Hotel on King William Street due to her schizophrenia. She caused $90,000 damage by setting one of the couches out the back in a beer garden alight.
Okay.
Nobody was there. It was middle of the morning.
Right.
Dark hours. No one hurt, just property destroyed,
Sure.
nothing else.
Mm-hmm.
This is where that oft-quoted paragraph from Judge Kimber comes from. Judge Kimber said to her, Ms. Laurie, a limiting term is not punishment. It's the appropriate period of supervision relevant to your conduct.
Mm-hmm.
It's a period to enable treatment to be conducted and for the community to be protected while you undertake that treatment. My paramount consideration is the protection of the community. In your case, inpatient rehabilitation is required and a significant period of inpatient treatment.
Okay. That on the surface, Sean, sounds reasonable and dare I say just in this situation.
Absolutely. And look, the limiting term, 5 years, 11 months, 9 days.
Okay.
He's saying, if I found you guilty of arson, I would give you a 5-year sentence.
Sure.
Instead, I'm going to give you 5 years, 11 months, and 9 days under supervision.
Okay.
And I am indicating that the majority of that should be served as an inpatient.
Right.
Now, to me, that's a sensible approach.
Yeah.
It's also a transparent one.
Correct.
Judge Kimber talked about, you've got a history of petty crime, and all of your petty crime comes from your mental illness. Now's the time to send you somewhere where you can get the help that you clearly and sorely need. And look, we've been quoting him for a reason.
Yeah.
There's no BS in this explanation.
No.
It's matter of fact, it's to the point, and even, she could understand that, which was fantastic.
And to your point, Sean, it makes logical, reasonable, common sense. And in this situation, it looks like it's been applied specifically and directly as it should be. That the sentence we would look at would have been just under 6 years. So that's the limiting term. Same situation. You're now going to go off to a detention situation, and what you need to do is serve the majority of that in that detention circumstance while you undertake some recovery and treatment. Ergo, the protection of the community as well is put in place. And when we look at that, and we said before, we can't measure these things, but when you talk about the fact that it's in a circumstance where there was no one else, there's no harm to other people, it was property damage, and I don't take that away, but it's not a case of physical damage and violence and harm to another person. I think in that element, that sounds fair and reasonable.
Absolutely. 15 minutes later, I cross the street and I go to the Supreme Court for the case of Thor Rasmussen. Now, Thor Rasmussen has been in mental health detention for a period of time. 6 years, in fact. 6 years ago, he fatally stabbed his housemate, Heath McPhillips.
Okay.
I was surprised to see Rasmussen's name on the list.
Sure.
It's only been 6 years. Of course, he would have been found guilty of murder, but as we all know now by playing this game, not guilty of murder by reason of mental incompetence,
Sure.
limiting term of life. It's been 6 years. Why are we back here?
Sean, that's sounding a little bit Donato Corbo-esque, and it's something we're going to have to really start to unpack. Sean, we've got a situation where a man has been stabbed to death by his housemate with a limiting term applied, and yet in a very similar feeling situation here, we're back in court within 6 years, starting to look at the concept of how do we reduce the circumstance. So do I want to know how this is all going?
What's happening is Thor Rasmussen's prosecutors, defense counsel, and doctors have all agreed he's ready to make day trips into the community, accompanied by just one supervisor.
Okay.
So that's a step below what Donato Corbo is seeking at the moment. We're further on down the process here.
Within 6 years?
Within 6 years.
Okay.
Bit concerning. Most concerned of all are Heath McPhillips' parents, Audrey and Ian.
Yeah.
And they took a really unusual step. They weren't present in court themselves. They hired a lawyer of their own to come and represent them in court.
Okay.
Remember we talked about next of kin statements?
Sure.
Not happy with the next of kin statement. Feel like the next of kin statement's not worth the paper it's written on.
Okay.
They want to have an active presence in court. And their lawyer actually read out a statement on their behalf.
Right.
Have a listen to this. We want to remind the court that Heath was a good man, a well-respected, hard-working man and much-loved son. To lose our son in such a graphic, violent and unexpected way has been immensely painful. The court process has been a deeply troubling time for us. We worry Rasmussen has no insight in relation to his illness, and we are fearful of him engaging in future violent acts. It was only in February this year that he reported to his doctors he was still hearing voices sometimes. So first and foremost, we want to ensure this never happens again. Rasmussen was supposed to be under treatment in the community when Heath died. Days prior, he had been assessed as low risk. Heath died on November 14, 2015. Barely 6 years have passed. This is a very short time.
Very short and very concerning from what you just read out there, Sean. A, he was already supposed to be in the community under under supervision there when this incident occurs. Yeah, look, and the fact that earlier this year alone, he still reported hearing voices.
Now, that shows how much the McPhillips are keeping on top of this situation.
Absolutely.
They're reading the reports that we're not seeing,
Yeah.
that I can't get access to.
That's concerning.
Very concerning. I was deeply concerned when I heard this. Unfortunately, because prosecution, defense, and doctors all agree that the time has come, that means that the evidence is all in agreement. That means when it comes to Section 269, a judge is obliged is the wrong word. A judge will tell me if I use the word obliged.
Sure.
But very much the evidence is there, the proof is there, courts operate on proof. As a result, all that Justice Anne Bampton could do was to tell the couple's lawyer that your client's grief and anguish is acknowledged by the court, and then agree to Rasmussen's day leave, ordering it be in effect immediately.
Wow, that's a bit of an odd one for me to hear that a justice in that sense, and I know it's not the case. I shouldn't be shocked. I should say they are obviously contained within the law and what needs to happen as well. And right there, we've seen that, not without using the word oblige, need to operate within that system, those rules we talk about.
That lawful decision.
Correct. Which means that technically, although she takes on board the concern of those parents and the lawyer who spoke on their behalf, the time has come based on the evidence presented.
Reminds me a lot of Michelle Chamberlain.
Yeah.
Saying, nobody's listening to us here. We really badly, we don't want Vicky to suffer. We just don't want her anywhere near us.
Sure.
Here's another step again. I actually spoke to Audrey and Ian afterwards and got in contact with them and let them know I was writing the story because I thought that's appropriate. And I'm not going to go into what they said to me, but this is a lovely couple who have obviously lost so much.
Yeah.
And they're struggling to understand why they don't have a voice in all of this.
Sure.
They're struggling to understand why it doesn't matter when they point things out. Now, again, I'm going to go back to the Vicky Wagner situation here. Michelle Chamberlain never had anybody come to her and say, this is what we think about your sister.
Yeah.
Tell us why you're afraid.
Okay.
Again, this is not happening here. Could it be that Rasmussen is in a place where he's actually really good? Maybe he's woken up, so to speak, and gone, oh my gosh, I killed Heath. He was my friend. I'll never be able to live with my guilt, even though it's not criminally my fault. But we don't know that.
No.
All we know is that as of February, he was still hearing voices. And we only know that because Audrey and Ian have reminded the court of it.
Sure.
We in the public don't know. You and I are big proponents of good mental health.
Absolutely.
I've struggled with mental health issues for several years now.
Mm-hmm.
I'm very public about them because I feel that by being public about them, I can help others understand.
Certainly.
I don't begrudge anybody who's not public about their mental health. That's their own business.
Absolutely.
In a court situation where, as Judge Kimber would have it, treatment and rehabilitation must be balanced with community protection, surely greater publicity, more understanding, and more transparency helps community protection. If Rasmussen is the sort of person who, as I speculated, might be quote-unquote completely okay now, and he's out having a coffee with somebody and someone recognizes him and points and says, you're a filthy killer, you murdered Heath, what's that going to do to him and his rehabilitation?
Yeah.
But if people maybe had more knowledge of what he's going through and understand it, then perhaps they'd look and say, there's that guy who went through that. I wonder how he's feeling now.
Yeah. That's a big ask, Sean. And what I mean by that is, again, it comes back to that really just nerve-jangling emotive piece around at our core, those primary responses are, that's the guy who killed. It takes a lot to ask people to go, why is that? What is that about? Do I have any connection, understanding, empathy toward that situation?
Then surely we should be front-loading the process.
Correct. And sorry, that's what I'm getting to. I'm actually advocating for exactly what you're saying here, because it is such a hard thing to do at the best of times. And certainly if you don't know the circumstance or aren't connected to that, or you have a connection, to the deceased in this part, your emotive part is going to kick in and take over, and that's your primary response every time.
Now, I don't mean to throw Justice Bampton under the train here.
No.
I applied for the court file.
Sure.
I asked for the psychological reports. I asked for the license conditions that Rasmussen will be operating under.
Sure.
Those requests were denied.
Okay.
What that means is, from a journalistic perspective, I'm talking about what I know from listening in court, from my own experience, and from what Audrey and Ian have told me.
Yes.
That's not a lot to go on.
No.
And we're bringing this case up not to say, look, guys, throw this one up in the air. Aren't you scared? We're bringing it up to say, why can't we know more so that we can have a proper, empathetic understanding? Why aren't we front-loading these conversations? If we have a section of law that is being used very often to determine that someone is not criminally liable for violent acts, why are we not front-loading the explanation to the public so the public understands exactly what that means? Why have we had to spend multiple episodes doing this when it could be part of that ongoing dialogue between the legal system and the community?
All wonderful questions, Sean. We clearly don't have all the answers. We generally pose more questions than that, and we're good at that. And to your point there, and it's about time we kind of touched on this, we have over the last few episodes highlighted some very distinct and emotive cases, and we've talked about some very distinct and emotive circumstances within those cases. And what we've tried to do here is, as we always do, we've tried to give you an opportunity, as I said a number of episodes ago, and hopefully this episode as well, the chance to have a blank canvas and to paint with some different colours, so it's not so paint by numbers we think we know everything. Now, we've had some very different circumstances and outcomes in these cases. We've had some really horrific crimes and violence caused against people. We've had people who have gone through a process, have recovered and been released. We have a situation where someone likely will never get to a point of being able to do that. We have another one where we are skeptical in the sense that, has that been a long enough time? We've had someone that it seems fair and just upon the situation that it was no other people and it was just us, and etc. And we've had one here that we just don't know enough about, but it seems very, very, dare I say, fraught with concern, right? That's a whole lot that we've brought to the table about this mental health situation when it butts up against the legal system. I say all that because I want to pose it to our audience, Sean, that through this situation and hopefully having a different paradigm and a different lens to consider this through, have we perhaps thought or felt anything different? We've given a lot of information. My question is, how do we feel about that information? Are we angry? Do we perhaps have some more empathy for situations and people we didn't understand before? I'm going to leave that question open to our audience because we do all this for a reason. And that reason is, next week, we are going to walk into one of probably our most decisive cases that will potentially cause derision in opinion and idea around the situation. It is a very high profile situation that we do not take lightly. However, you and I are both walking headfirst into a situation that needs to be discussed and talked about.
And you will need to know everything that we have told you to this point to be able to apply that knowledge and to be able to think, to come up with what you think is the right call here.
It's fair to say that a lot of people already have an opinion on this.
Calcified opinions, I'd go so far as to say.
And they're incredibly emotive. And you'll understand why when we get to talk about this situation. Until then, we want to thank everyone who has listened to the broadcast on 5AA or has caught our episodes on either iTunes or Spotify. We would love for you to go rate, review, and leave us a 5-star, obviously, and commentary and all of those wonderful things that help us get our message out to the wider audience that may take some benefit from our messages. We just want to also remind you that if anything you have heard on this episode or any of these episodes causes concern, the South Australian Government Mental Health Triage Service on 131 465, the Acute Crisis Intervention Service Support Line on 131 466, or the relevant local services in your area.
Don't hesitate. You are helping someone when you do these things.
For all of your commentary, feedback, etc. that you may want to give to us, please, you can do that at Just Lawful Podcast on Facebook and Instagram, at Just Lawful Pod on Twitter. You can follow all of Sean's work with Adelaide's True Crime and The Advertiser at Sean Fuster on Facebook and Twitter. I'm going to suggest you keep an eye on our social media throughout the week as we start to tease what the next episodes are all about and the next series we tackle. And until then, we want you to enjoy our work, but don't become our work. And we'll speak to you on the next episode of Just Lawful.